What happens to your assets in India when you are no longer there to manage them? Hello everyone, I am Advocate Avantika Raita. Today I will help you to understand why will making is not just important, it is very essential for NRIs. When you live as a non-resident Indian, managing your assets back in India can often become complex, whether it's property, bank accounts, investments, or ancestral wealth. One crucial legal document that ensures everything is handled smoothly after your lifetime is a will. A will is not just a document, it is your voice when you are no longer there to speak. For NRIs, making a will become even more important because your assets may be spread across multiple countries. Without a valid will, your families may face lengthy legal procedure, family disputes, and even financial losses. Let's understand why will is important for NRIs. Firstly, it provides clarity and control. You get to decide who will inherit your assets in India, whether it's your spouse, children, or any other beneficiary. Without a will, your estate will be distributed according to Indian succession laws, which may not align with your personal wishes. Secondly, a will helps in avoiding family disputes. In many cases, lack of proper estate planning led to conflict among family members. A well-drafted will minimizes ambiguity and ensures smooth transfer of assets. Thirdly, it simplifies a legal process if your will is properly executed. It becomes easier to your legal year to obtain probate and claim ownership of assets without unnecessary delay. Now let's talk about how an NRI can make a will for assets in India. An NRI can create a will either in India or abroad. If a will is made outside India, it should be signed in the presence of witnesses and must be notarized from Indian Embassy. This adds authenticity and reduces complications later. It is also advisable to clearly mention all your Indian assets like bank accounts, investments, any other digital assets. A will should also name an executor, a person who is responsible for carrying out your wishes. Another important point is registration. While registering a will in India is not mandatory, it adds an extra layer of legal strength and reduces the chances of future disputes and challenges. NRIs should also be mindful of multiple wills because if you have assets in different countries, it is better to create separate will for each jurisdiction to avoid conflicts between legal system. Now let's look at some practical challenges that NRI face without a will. Imagine an NRI who owns property in India but passes away without leaving a will. The legal heir may have to go through complex succession procedure, obtain legal heir certificate, and in some cases approach court for resolution. This can take months or even years. In another situation, if a will is made abroad but not properly attested or aligned according to Indian legal requirements, authorities in India may question its legal validity. This again led to delays and complications. So at this stage, the most important question arises: what actually make a will strong and legally effective? What are the ingredients of a good will? Let's understand in the practical and professional way. A good will must clear identity of a person who making it, the testator along with NRI status and declaration of sound mind. This avoids future challenges on mental capacity. Next, the will must contain complete details of assets. Especially in India, property description should never be vague. For example, in the case of agriculture and ancestral land, mentioning khasra number, khata number and land location is very important. If these details are missing, it can create legal disputes regarding execution. Similarly, for urban property, proper address, registry details and ownership documents should be clearly referred. Another key ingredient is clear distribution. Who get what? Avoid general mistakes like all assets to family. Instead, specify exact shares and beneficiaries to eliminate confusion. Appointment of reliable executor is also essential. Someone who can practically manage the formalities in India. Proper execution of a will is equally important. It must be signed by the testator and witnesses. For NRIs, it must be notarized from Indian Embassy. Now let's clarify an important misconception: what is not required in a good will. A will does not require registration to be valid under Indian law. A registration is optional, not compulsory. There is no expiry date or time limit for a will. Once made it remains valid until it is revoked or replaced by a new will. Stamp paper is not compulsory. A will can be made on plain papers. And importantly, there is no deadline within which a will must be executed after drafting. It becomes effective only after the death of the testator. However, from a practical perspective, updating your will is very important, especially after major life events like marriage, birth of children, acquisition of new assets. So, a good will is not about complexity, it's about clarity and completeness and proper execution. When these elements are in place, your will become practically enforceable and legally executable in India. Because at the end of the day, a well-drafted will is not just distribute assets, it prevents disputes sometimes and protect your family's future. Plan today so your loved ones do not struggle tomorrow. A well-drafted will is the strongest gift you can leave behind. Thank you for watching this video. If you like this topic, don't forget to like, share and subscribe NRI Legal World.